for some analysis on eviction laws following the Marshalltown building fire yesterday, we are now joined by legal expert, Advocate Khumisi Kganare. Advocate, thank you so much for your time this evening and for joining us. Now, the Marshalltown building that caught fire yesterday was last inspected in 2019 before it got evicted. And in that same year, 140 foreign nationals were arrested for collecting illegal rent from tenants. What recourse did the city have over the time in terms of evicting those tenants?
Thank you very much, and a very good evening to your viewers. And my condolences really to families of the victims of this ordeal. Essentially, look, there are processes to be followed when you want to embark on an eviction process. And mainly, there's two requirements. You would have to, deal with the substance of it. Number one, being that the people that are occupying the property in question are, unlawful occupiers. And, when that has been established, then you can go on to, the next leg where you deal with the process that you need to follow. On how you should get them evicted, and essentially it's a question of giving them notice 14 days before the hearing is set down for the eviction in question.
So the process would also entail that the responsibility is upon the landlord to ensure that they have got sufficient shelter once you evict them. Does this also apply in terms of illegal evictions?
Yes, well, look, it all flows from the Constitution, and whether or not the occupier is there lawfully, it really doesn't matter. The process is very clear that if you are a landlord, and I mean there are arrangements that would apply and specific processes that would apply to landlords that are embarking on this process. But if it's somebody else, for instance, let's say government, you would have to cancel or withdraw the consent as a landlord. And give the occupier that notice that we had an arrangement, be it a rental agreement or whatever, that I'm now cancelling this arrangement that we have, and or withdrawing it. Please vacate the property within a specific period. If they fail to do so, then you can exercise your right to approach court. Where you will be given, an opportunity now to put down your case about, the unlawful occupier, circumstances around why you would want them to be evicted, and they are also given an opportunity, to oppose whether or not they are, legally there or not, to oppose your application as the landlord.
There's a notion or an understanding that tenants generally have the upper hand when it comes to evictions. Is this the case? Is that true?
Not really. And if we are talking here, about tenants that are renting by way of, a lease agreement, it's an agreement between two parties. If the landlord, for instance, now, terminates the agreement, the only upper hand that I would say, tenants enjoy is that they cannot be, evicted from that property illegally. And now what that means is that the landlord will have to spend money to go to court, because the Constitution says no one can be removed from a property without a court order. Now those are the expenses that the landlord would have to incur to, have the tenant evicted out of the property. But, obviously, he or she can always recover those costs later. But again, it's not guaranteed they will be able to do so. And that's the only, upper hand I would say tenants have over landlords. But landlords are also protected because they can exercise their rights, within the bounds of the law, as long as they are able to, prove to court that this an unlawful occupier. And in terms of the PI Act, I mean, you are an unlawful occupier if, you are there without consent of the landlord, or you don't have any legal right to occupy that property. The third one being that you are not considered to be an occupier in terms of any other law. And as soon as that has been established by the landlord, now they just have to follow that process where the tenant is notified that the consent has been withdrawn, and that must be in writing. It's a long process, but they have to do it nevertheless. Observe the law, and if the tenant still does not move, the landlord then will have to approach court to go and get recourse therefrom, where again the tenant will be given an opportunity to oppose, state their case why they should not be evicted. And one of the things that court would have to have a look into now, after having heard both parties, if the tenant, for instance, has been there for less than 3 months, for instance, it's a different situation from where a tenant has been there for more than 6 months. And if it's less than 6 months, then court does not necessarily have to consider issues of alternative accommodation. But if the tenant has been there for over 6 months, there is that additional consideration of whether or not the landlord or the owner of the property has made arrangements for alternative accommodation, or the municipality in that area of jurisdiction. That's why you as the landlord would have to cite the municipality as a respondent, so they can also try and make arrangements. There's issues of the elderly, women, children, and family that are led by women or children, as consideration that court would have to look into whether or not it would be fair for them to grant an eviction order. So basically, those are the requirements that would have to be ticked by the landlord, and court will have to have a look into those factors.
I mean, you speak of the process being so long. In your line of work, what do you often find to be the mistakes that landlords make at the beginning of the process that then has them not having the upper hand in terms of removing a tenant, especially if it's one that's occupying illegally, like removing their property, the immovable property from the property, as an example?
Remember, unfortunately for landlords, it's most of the time a business arrangement, and when you do not get paid as a landlord, to some extent you get upset, and you make a lot of mistakes in you being upset, when you deal with the tenant. The property, assets belonging to the tenant, that's also a right that the landlord has. It only depends on how they exercise it. We call it hypothec, where they have the right to, hold on to the tenant's assets as security until this whole process is done. So they can also recover, if at all the tenant is not able to, settle the outstanding debt. So I would say it would be acting out of anger from the word go, not handling the tenant properly, not giving them notice, trying to bully them out of the property. Those are the things then that when the tenant now gets an opportunity to oppose, your application as a landlord, then they would have, an opportunity to and under oath, produce those incidents as evidence, which might tarnish your case as the landlord.
Lastly, in relation to the Marshalltown building, we know that the scourge of hijacked buildings, especially in the Joburg CBD, has been a crisis over many years, and government in the city has sort of now placed blame on NGOs who, through court orders, have stopped the city from evicting tenants that are occupying these buildings illegally. What stance do you believe that these NGOs had in refusing for these tenants to be evicted?
Look, the law is the law. Whether or not people are, and like I said earlier, whether or not occupiers are there lawfully or not, there is clear law, clear processes on how you must deal with them as a property owner, landlord, or government. And number one, you need to tick, there's two main things that you would have to tick off this exercise as the landlord, as the municipality or the property owner. Satisfy yourself that these people are unlawful occupiers, that they are there not having the right to be there. And there is number two, a clear process that you need to follow. If it's a lease agreement arrangement, you must terminate that arrangement. You must cancel it. You must withdraw your consent. It must be in writing. If it's government doing it, you need to notify them that they are an unlawful occupier or occupiers of the property. You need to give them notice. You need to give them about 14 days before the hearing, within which they will have to also prepare their own papers if they believe they have some defense. And if these processes are not followed, it creates a very proper ground for NGOs that, or even civil society that represents these people to approach court and also exercise that right to oppose the eviction. And at the end of the day, it's court that will have to sit down with these things and decide. Looking at the time, for how long the occupiers have been there for, and also if they are elderly people, if they are children, if they are women, and those are very serious considerations that court would have to take into account when coming to its decision. We have another thing that, but it happens. It doesn't happen a lot, where you can own property just by prescription. After 30 years, if you have been occupying it uninterrupted for a period of about 30 years, then you automatically own it in terms of our laws.
All right, Advocate Kganare, thank you so much for your time and for your insights this evening. It surely was quite insightful. That was legal expert Advocate Khumisi Kganare speaking to us there about the laws of eviction.